Labor and Industrial Law by M.G. Law. Now we will cover registration of trade union, page number 5. Registration of trade unions. So under Trade Unions Act 1926, in section 4, it is written that the minimum number of members who should apply for registration is 7. At least 7 or more members, at least 7 members should apply for the registration. 7 or more members of trade union may apply. Okay. In section 4, it's subsection 2, it's given that if after application and before registration, okay, after the application but before registration has not been done yet, if some applicants, okay, cease to be members, or they give a written notice to registrar of dissociation from application, okay, if some members who applied, they are not member anymore, okay, they are not the member of the trade union now, or they have given a written notice to the registrar that we are dissociating ourselves from the application, okay, if the number of these members is more than half, then there will be no registration. If the number of members is less than half, then there will be registration. For example, if 7 members applied for registration and 4 take back the application, then there will be no registration because it's more than half. But if only 3 take back the application, okay, or 3 cease to be member of the trade union, then the registration will be allowed. With the application, a copy of rules is also submitted with every application. Okay, what are these rules? These rules are related to the name of the trade union, the object of the trade union, the funds purpose permissible under act, okay, how to spend the fund, the purpose of the fund, okay, it should be permissible under the act, the rules related to how to maintain the list of the members, how to admit new members, the rules related to payment of subscription, the rules related to benefits and fines, how to amend or vary or resign means remove the rules, okay, the rules related to appointment and removal of the members, executive and office bearer, and the rules related to how the trade union can be dissolved, okay. So these are the rules. A copy of these rules will also be submitted with the application for registration. Then further particulars and name alteration, if in the opinion of registrar there is non-compliance of rules are not being complied, then he is empowered to call for further information. He can call for further information for satisfying himself that the rules are being complied with. If the name of the trade union is identical with any other trade union or it nearly resemble it, then the name of the trade union has to be changed, okay. Next step will be the registration of the trade union. Now the trade union will be registered by the registrar, and after it he will issue a certificate, okay, certificate to be issued. Registrar is bound, he cannot refuse, okay, registrar is bound to issue the certificate. Withdrawal or cancellation of registration, okay, in two ways. The registration can be withdrawn or cancelled either on application of the trade union itself or on the will of registrar. So the first way, on application of trade union, how? After proper steps. First there will be a general meeting of all the members, office bearers and executives, and if the majority pass a resolution that the registration should be withdrawal or cancelled, then the application will be submitted for withdrawal or cancellation. There is no need of 2 months prior notice by the registrar through this method. But if the cancellation is on the will of registrar, he can cancel on the grounds. These grounds are if the certificate is obtained by fraud or mistake, okay, or if the trade union ceased to be exist, okay, the trade union is no more, or the trade union contravened any provision, okay, it goes against any rule or law, or it violates any rule or law willfully and after notice, okay, after the notice was given, then also it was willfully violating the rule, okay, or the trade union allowed any rule which was inconsistent with trade union act, okay, or the union resigned any rule providing for the manner of appointment or removal of executive or office bearer. If they remove any rule which provides for the manner of their appointment or removal, or the dissolution of trade union, okay, then also the registrar can cancel the registration. For this, the registrar has to give 2 months prior notice, okay. Next will be remedies for if the registrar refuse to register, or there is withdrawal of certificate, okay, or there is cancellation of certificate. For these, the remedy will be appeal. So who can appeal? Only such person whose rights or interest are affected by the order, okay, only that person can appeal. A stranger cannot appeal. The person can be a natural person, okay, any member, or an artificial person like the trade union itself. The trade union can appeal against the withdrawal or cancellation. Where can they appeal? They will appeal in the courts. First, in the high court, if the head office of union is within the limits of presidency town. Presidency town are Bombay, Madras, and Kolkata, okay. If the head office of the union is within the limits of presidency town, then the appeal can be done in high court. Or if the head office is not within the limits of presidency town, then the appeal can be in the court not inferior to court of additional or assistant judge of principal civil court. This court will be appointed by appropriate government, okay. The appeal can be done against this court's order to the high court of that area. What are the powers of appellate court? The powers of these courts are either the court will dismiss the appeal after hearing the parties, okay, or it will direct the registrar to register and issue the certificate of registration, or it will set aside the order of withdrawal or cancellation on merit. This order is binding on registrar. He has to comply it without any delay, okay. The procedure followed by these courts is same as civil procedure code. So this was appeal. So what we have done, registrar of registration of trade unions, how it's done, like 7 or more members. If after application before registration, some applicants cease to be members, or they give written notice to registrar for dissociation. If they are more than half, no registration. If they are less than half, there will be registration. A copy of rules is also submitted with the application. If in the opinion of the registrar there is non-compliance of rules, he will call for further information. If the name is same or nearly resemble with any other trade union, then you have to change the name of the trade union, okay. Then their registration will be done and certificate will be issued, okay. The withdrawal or cancellation of certificate or registration, it can be done in two ways, on the application of trade union itself, or on the will of registrar. When the trade union applies, it have to follow proper steps, like there will be a general meeting, and the resolution for cancellation of withdrawal will be should be passed by majority. There is no need of 2 months prior notice by the registrar. On the will of registrar, there are certain grounds which have to be fulfilled, like the certificate is obtained by fraud or mistake, trade union ceased to exist, or any provision has been contravened willfully and after notice, or the trade union has allowed any rule which is inconsistent with the trade union act, or it has resigned any rule which provides for the manner of appointment or removal of executive or office bearer, or dissolution of trade union. In this method, a 2 month prior notice should be given by the registrar. The remedies for refusal to register or withdrawal of certificate or cancellation of certificate, the remedy is appeal. Who can appeal? Only such person whose rights have been affected by the order, or the person can be natural or an artificial person. That, like the artificial person, trade union is an artificial person. It itself can appeal against the withdrawal or cancellation. Where the appeal will be, that the appeal can be done to the courts. One is high court if the limit If the head office of the union is within the limits of presidency town, Bombay, Madras, and Kolkata, then the appeal will be done in High Court. If it is the head office is not in the limits of presidency town, then the appeal will be in the court not inferior to court of additional or assistant judge of principal civil court. It will be appointed by the appropriate government. The appeal to this court can be done to the High Court of that area. What are the powers of the appellate court? They can dismiss the appeal after hearing the parties, or they will direct the registrar to register and issue the certificate, or they will set aside the order of withdrawal or cancellation on merit. This order is binding on registrar. He has to comply it without delay. The procedure followed by these courts is same as civil procedure code. So this was registration of trade unions. If you are interested in the PDF of these notes, you can get the link in the description box or the comment box. Next topic will be rights of registered trade union, which we will cover in the next video.